Hey, it's me, Rocky. I'm back to talk to you today about mediation. Now, here's where we are. We're in litigation phase. We've done discovery, and we've done deposition, and we've probably done expert disclosure. And now the court has informed us that we need to go to mediation. Most of the local rules of court have a rule that before we can get a trial date, we have to go to mediation. Now, mediation is what's called an alternative dispute resolution technique. And there are a couple of those. There's arbitration and there's mediation. We're going to do mediation. But let me tell you what arbitration is. Arbitration is an informal proceeding where a lawyer, a non-judge, makes the determination after hearing evidence of how much compensation you will receive. It's something that we don't have control over. In mediation, you have all the control. It does not have to settle. You are in charge of saying yes or no to the ultimate offer made by the defense insurance company. Now, let me be honest. I don't like mediation. If I had my way about it, we wouldn't go to mediation, but in very few cases. I believe mediation sets us up to settle the cases for less than they're really worth. But if we're made to go there, we got to go there and participate in good faith. So, here's the process. Before your mediation, the lawyers in my firm are going to conduct a roundtable where we're going to talk about the value of your case. And we're going to reach a number which we think is the bottom line dollar we should take for your case as a group, using all of our experience and our expertise. Then we're going to have a meeting with you where we talk to you about your case, the strengths, the weaknesses, the pros, the cons, the ups, the downs, and anything that might be sideways. And we're going to let you know what the number is that we think is the low dollar we should take at mediation and ask you to sign off on that number. That way, when we get to mediation, we're not going in to take just anything they offer us. We have a goal, and if we don't reach our goal, we need to leave. After that meeting, where we talk about the value of your case, we're going to have a date where we go to mediation. It's usually downtown Nashville, or in those high rises where the mediators work. Mediators are typically lawyers with 30 to 40 years of experience in litigation. Typically, they are defense attorneys, lawyers that have spent their career advising insurance companies. And the reason it's that way is no insurance company is probably ever going to listen to me, Rocky McElhaney, on what a case is worth, because I'm a plaintiff lawyer. I don't represent them, and they don't trust me, right? So we go to mediators that the insurance companies are used to trusting, okay? So that's how it works, and that's fine with us. We've got a list of really good ones that we like to go to, okay? So we go to their offices, and we go to a conference room, and the defense goes to the conference room. Now, if we do our job right, and the judge don't let them out of it, we will require that the money decision maker from the insurance company, the person that pulls the purse strings, that controls how much money is offered to you, is there in the mediation in the conference room, present, on site, not by phone in Cincinnati or Bloomfield or anywhere like that. They're in the office. So once we get there, we get squared off in the conference rooms, the mediator will come into our room, spend 10, 15, 20, 30 minutes with you, getting to know you, letting you get to know the mediator, explaining the process to you, and learning a little bit about your case. We will send them materials in advance, okay? I will send an analysis with case materials that I think are important, and the defense will send them case materials with issues they think are important. I'll be focusing on why we have a great case and why you should get valuable compensation, and the defense will be focusing on why you should take less or be paid less. The mediator will then go back and forth between the rooms, carrying offers back and forth. It's a negotiation process. It's a give and take. If the case is going to settle, we have to come down and they have to come up. It only settles if you are happy with the amount of money offered at the end of the day. Now, hopefully you will ask our opinion and follow our advice, but you have all the control at mediation. If the case doesn't settle at mediation, it's as it never happened. Everything at mediation is confidential. The mediator can never be called to come to court to talk about anything that happened at mediation. Mediation is entirely confidential. So that's the mediation process. And as we get closer to mediation, we'll be doing this roundtable and bringing you in to talk and prepare. But again, as I've said through most of these videos, there's really no reason to be worried. In the mediation, you'll only be dealing with your lawyers, okay? So only in a room with your lawyers and the mediator, and there's no reason to be worried. The worst thing that happens at mediation is we don't settle. The best thing that happens at mediation is you do settle. So that's where we are, and we'll be in touch soon. Thank you.